This is Professor Joel Reidenberg of Fordham University, also spending, is it this year at the University of Paris, who will speak about the global IP order and privatization of public law. Professor Reidenberg is an expert on information law and policy. He's co-authored a couple of books and authored many articles. He's testified before the U.S. Congress on data privacy issues, and he's promised to liven up this conference at the very, very end.
Thank you. I hope I can live up to that. It's wonderful to see everyone sticking it out to the very last minute.
I don't hog the lectern after I talk about sharing.
Let me start first by saying Toda Rabah to Neva and Michael and to the IDC for the invitation to join you today. It was a real honor for me to be able to come to Israel to participate in this great conference. And I have to say I've had a chance this year to participate in a lot of conferences since it was my sabbatical year. And this was the one I was looking forward to the most the whole year. So I really appreciate the opportunity. My topic, I'm going to pick up on one of Yochai's concluding points because I think it provides a very good transition into my paper. He focused as one of the conclusions on looking at the non-market function. And the non-market function that he's describing is really a means to bypass legally set priorities. Because one of the other quotes was, in the formal lawmaking process, we lose. And what I'm going to talk about is the dark side of that approach. Because as the topic that I gave listed as the global intellectual property order and privatization of public law, what I'm going to focus on is how in the post-TRIPS period, IP law has been, the way IP law has been adapted in the internet context, so it's largely from the copyright sphere, is really a reflection, or it's at the center of a struggle between democratic governance and network rules. And we see a trend toward a privatization of public law, public function of copyright law, and a response which is really a type of insurgency movement that's been led by technology developers and technologically savvy users against democratically chosen IP rules. And that suggests to me that there is a very profound challenge going on here that is a challenge to the rule of law itself, centered around really the key question: who controls the rules that are going to be wired into the network? And the sense that we look at a non-market sphere is really a rejection of the IP regime because a group has lost in the formal rulemaking process. So let me start with really the basic point that IP law has a public function in democracy, and we see it expressed in TRIPS. If we think about IP law, it really sets the demarcation lines in society between economic, political, and social interactions. We saw quoted yesterday the U.S. Constitution, the Punta del Este Declaration setting out the marching orders for the TRIPS negotiations. And in each of these instances, what are we looking at? We're looking at patent and copyright, providing incentives for innovation, balanced with dissemination of the knowledge, or in the case of copyright more precisely, how we create and distribute information. Michael's talk earlier this afternoon looked at this, the freedom of expression and how that plays out in copyright law. These are all political and economic objectives that societies decide. They set these balances in statutory law. We see the same thing in TRIPS. TRIPS had a very conscious political objective. The linkage between IP and trade was a promulgation of a particular kind of economic vision, a philosophy, and a market structure. If we look more specifically at copyright, and I think this really draws a lot on what Michael was saying earlier today, there's really a fundamental link between what the copyright law does and how a democracy is functioning. Neil Netnell has written some wonderful work in this area as well. How far do we go? What's the balance between speech and what's the balance between protection of expression is really anchored in a liberal democratic philosophy. This type of position, this form of anchoring, we see it expressed most recently in the Copyright Convention from the WIPO. And when we look at what's happened in the evolution of IP rights over, say, the last decade or so, we come to what's really the second point I have to make, is we've seen a redistribution of rights, this privatization itself. There has been a global shift in the substantive law from protecting the content itself, from focusing on what is the nature of the protection of content. Is it 15 years? Is it 75 years? What's the duration of the content protection? What are the parameters of the rights? To access protection. We now talk about technical measures. The law protects technical measures used to protect the information. It's enshrining in law protection of digital rights management. Well, the digital rights management is really about how we get to the information. Who gets to control the access to the information itself. And it's very significant because it's shifting control from the publicly defined allocation in the copyright law. We'll go back to fair use as an example from copyright. Copyright has a fair use right. The public law defines it. Well, what happens now if it's in a digital package and the digital rights management system, the technological system, sets it out differently from what the public law might have allocated? The public law also prohibits undermining the technological protections. So we see in that interaction, in essence, of the privatization and an ability for the content owner who's packaging using digital technology, that content owner has an ability to define in new ways how the product is used. And those ways can be outside what the public law was originally setting out to do. And it's unique, I think, in the digital environment because of this interaction with the technical protection rules that we now see elaborated around the world. And we see a couple of the examples. Where is this coming from? We see it in the WIPO Copyright Treaty, Article 11, the anti-circumvention provision. And this impact, I think it's worth emphasizing the impact. By allowing the protections for the technical measures, we shift to the private contract realm how digital information gets distributed in a very important way. Because now it's the licensing of the technology, it's the licensing of Acrobat Reader or whatever the new ebook version might be. It's the licensing of the reader technology that defines, in part, the balance between dissemination of the information itself and the benefits, the value given to the creator. This position is then implemented in national laws. The U.S. has the DMCA, the EU has the Copyright Directive, and we're seeing that trend. A second area that's an interesting example where, somewhat different, but I think we also see this notion of a privatization is in ICANN and what happened with ICANN. The namespace, the Internet Domain Naming System. We see with ICANN this organization being set up to privately allocate domain names outside the public law. Outside the public law in the sense that if it were a public corporation as it was sort of initially, or at least publicly managed initially, you could look to administrative law to protect various rights, citizen social rights. If you set it up as a private company without that type of check on it, as Michael Frumkin has written, you're taking it outside the public law sphere and you're privatizing it. So you're privatizing this function. We see another interesting example, which is the public enforcement of private rights. And we think of the Skylarov case, where the geeks were marching in the streets, I think, was from the slide that Deborah showed us yesterday. In what other areas do we see? We don't see a public prosecutor coming in and arresting someone for a standard breach of contract claim. Here in the IP world, we've now criminalized certain kinds of violations, certain kinds of uses of an owner's, content owner's IP. So we have a transfer that takes place where we move toward access protection. We give special protection to the technologies so that the technical wrapper combined with contract gives the content owner a greater ability to choose an allocation of rights that may not be the same as what the public law has defined. And then at the same time, we're now allowing public authorities to enforce those private rights and help the private party enforce rights in an extraordinarily powerful way. Well, and many of us are at odds with that trend. But what's interesting about the trend is that these are what I would call democratic choices. If we look at TRIPS, TRIPS was adopted by 147 countries were signatories of the WTO agreement. The WCT has 47 signatory countries. These were decisions at the horizontal, it's sort of democracy at a horizontal level between states. States are choosing to buy into this for whatever reason. We heard, I think it was yesterday, some states may have bought into TRIPS not because they agreed with it at all, but that was the price of being part of the World Trade System. That's fine. That's still a choice by the state to move into this regime. At the implementation level, as we heard earlier, copyright is implemented locally. The implementation occurs through parliamentary enactments. Those are national choices. The strictness of the DMCA in the United States, the stronger protection stance of the DMCA probably goes further than the WCT would require. That was a national choice, often made by democratic states. So you have this privatization trend taking place that are conscious political decisions by governments representing their countries, in many countries elected governments. And what happens? Now, the third point, we see this battle for control over the rulemaking. The non-market players, those who lose in the formal rulemaking process. Well, in many cases, it's been the online community has objected quite vociferously to this trend. Technical elites, technical savvy users often will disagree with these reallocations or adaptation of copyright to the online environment by legislatures. And there are certainly many objectionable points. We can object to the substance of some of the rights. We can object to the adoption process. We in the United States have the best Congress money can buy. If you're a civil society person, you don't stand much of a chance. So we can certainly object to the process. We can object to the rights. But at the end of the day, unless we are objecting to the very basis of our democratic system and government, that's the choice that the polity has adopted. Well, we see this protest movement, this online protest movement. I'll divide them into two camps in a sense. There's what I'll call sort of democratic protests, which are those that are you would think of as being more part of a traditional democracy tug-and-war. Tremendous scholarly criticism of these trends in the IP world. That fits in. That's the typical kind of way we debate public issues. Social movements, the protests in the streets, to the degree that they're peaceful at least, those are the kind of traditional participation in public debate that we see, at least I would see, as part of democratic expression. Then there's another kind that I think is the troubling kind that we've seen coming from the technical world, which are what I'll call anti-democratic insurgents. And this is in part a movement for the evasion of the rule of law, not avoidance. Avoidance, we think of tax avoidance. You have lawyers that try to structure a deal to benefit from various tax rules. You incorporating the Caymans to benefit and so forth. There's a difference between tax avoidance and tax evasion. These are evasion schemes. And here, P2P software is the case study, the study in point. And we look at Napster and what Napster was, in essence, what it was designed to do. It's file sharing, but what was Napster, the creators of Napster, at least as found by the trial court in the United States, said they were designing a system to trade other people's music. Napster loses in court. We see Fast Track and Nutella come into play. And Nutella, what's interesting here is while Nutella at least cynically claimed it was not a music piracy tool, I'm going to quote from the developers. Their advertising was, and I quote, they designed technology, quote, to withstand lawyers and be absolutely unstoppable. So they were designing the technology for the purpose of trading other people's copyrighted music and trying to do it in a way that they could evade the legal regime. In that sense, they're designing a program to frustrate the copyright rights that were decided by the World Copyright Convention and implemented nationally by parliaments and legislatures. It's a difference, I think, between civil disobedience and civil selfishness, in a sense. It doesn't strike me as having the kind of moral appeal that a civil disobedience and protest movement might have when you design software in this fashion. My next example, which I think is the one that may be the one a little more controversial, I'm not sure if it really quite works fully, is open software, or open source. Yeah, open source at its origin, it's a very clever and sophisticated kind of idea. But look at its origin. Look at Richard Stallman and the philosophical underpinning of open source. I'll quote from Stallman. Quote, I consider that the golden rule requires that if I like a program, I must share it with other people who like it. I cannot in good conscience sign a software license agreement. That's its starting point. Okay, the starting point is a complete rejection of intellectual property rules as adopted by legislatures. He rejects that. Now, it's ironic or hypocritical, depending on how you want to focus on it, that the way he tries to accomplish this mission, because it really is a religious mission for him, is through copyright licensing. And in the copyright licensing, what's interesting about it is that it's a very onerous license, in effect, that he's seeking to impose. Because the license is you can only use the stuff if you agree to make it freely available to others and any other derivative works are freely available to others. So he's imposing some very significant licensing conditions to get this idea out there, which is essentially a fundamental disagreement with intellectual property rules. Now, one of the aspects to this is that it's in effect seeking to use the market because if it works, suppose it works, and it's very successful, it's using the market to impose political values on the network community. Because within the open source, there'll be open source products that will be out there and the preeminent products in the marketplace. Those products are not neutral. The technology is not neutral. It embeds values. So the political decisions that will be embedded in open source products may offer no protection to minorities, minority interests, whether they be political interests, whether they be commercial interests, whatever it might be. The point is it's using a system to go outside what the public law has been defining as the society's allocation of rights. It may turn out, and we see with the adoption by Sun and some other big players, that open source may begin to move more toward a democratic protest type movement than this insurgency we saw at its origin. But it's a very, I think, an interesting example. this sort of what Neva said earlier this morning. It's a social movement seeking a legal reform. It's going outside, it's trying in a way going outside legal change, objecting to the legal system. What lessons might we learn from this? I mean, where would this take us? I think it suggests that we have a challenge that goes far deeper than any particular issue. And it's really reaching to this very commitment to the rule of law in a society. To the point that if we decide we can't win in the legislatures, so now we try to bypass the legislatures. It's a very anti-democratic position. It's about how we should allocate the control of code. Who gets to decide that? If we reject the rule of law, that starts to take us down, I think, a very dangerous path. How does society channel online opposition? Because in part what we're seeing is, it's an opposition movement. It's an attempt to change social norms, hope which may in turn eventually change the legal world, but this is the beginnings of an online opposition movement. How might we change it? Or how might it be channeled? I would suggest that states really can't accept that the public law or public rulemaking be contradicted, because then you're undermining the legitimacy of the state itself. And I think, interestingly, states have lots of tools, online tools, to assert the rule of law and bring it back in. And I'll come back with sort of an interesting conclusion, I hope it's an interesting conclusion, on open source. I think open source has a very significant Achilles heel. And that comes from litigation. In that we see with the SCO case, I think it's a tip of an iceberg. Anyone who wants to, either maliciously or not, may find it very easy to tie up and create instability in open source products by threatening litigation. And why? If we think about some of the tools that states have, one of the things SCO might have done, because it's in the U.S. copyright law, they didn't do it. As far as I know, they didn't try to do it. U.S. copyright law provides for ex parte seizure of copyright infringing goods. Well, if SCO has a good enough claim, you imagine the trouble it would cause if the company that is claiming some of their proprietary software wormed its way into open source goes to a judge and on an ex parte basis gets a seizure order for all of the computers in Citibank. Right? It'd be pretty striking. Could it happen? Possibly. Would a judge be that daring? Probably in that case not. But the point is, there are a variety of mechanisms that are out there. I think we will see states beginning to use them. We can see the same kinds of online enforcement taking place for violators. The Napster, or users of P2P products, states could order enforcement actions taken against the users themselves. Send out bots on the network to find out who's downloading whoever Red Hot Chili Peppers' latest song and wipe out their hard drive. That was a proposal. I think Hatch came up with something that was a little bit on the crazy lines. But those sorts of things I think we're going to see a lot more of, precisely because I don't think states will sit by, nor do I think they should, and see the sense or the notions of the rule of law being undermined in democratic societies. Not close to it.
I believe Neva and Michael gave this session the prescient title, Controlling Code. I'm going to have to control the controversy here. Mr. Binkler, 1 minute.
I love it when I get to be the free market libertarian on the panel. I think it's important not to confuse the rule of law with a particular policy conception behind a particular rule. There is a particular model of behavior that is consistent and underlies the law of intellectual property. But as Neva so clearly stated in her talk on Creative Commons, the core of that movement, the core of the free software, open source, Creative Commons movement is an advocacy for the voluntary adoption of new social behaviors in the context of existing law, in reliance on existing law. So, to say that behavior of individuals that is entirely consistent with law, in fact uses law precisely to give them the author control, that has the consequence of producing software and other things that other people voluntarily use because it's better, or the price-quality trade-off is better, or whatever they chose, is anti-democratic and objects to the rule of law because it does not comply with a particular behavior that was assumed by the legislature. That's totalitarianism. That's not the rule.
I don't think that's totalitarian because I guess what I'm focusing on is if the underlying philosophy is a rejection of the intellectual property regime and intellectual property rights. Let me back up. I see a bit of a distinction between the Creative Commons and the Stallman free software movement, in that the Stallman free software movement starts out as a movement that completely rejects the notion of intellectual property rights. The Creative Commons movement doesn't strike me as starting out with that same kind of philosophy. The philosophy is that there are authors out there that want their knowledge to be available in a variety of different means, some of them clearly part of the normal copyright process. And I don't think that's the same thing that was at the origin of the free software.
I don't think the motivation and political theory underlying a practice that is itself free and legal should matter whether or not it is a challenge to the rule of law. A consumer boycott and a refusal by consumers to buy products both exercise the same right not to buy something for different motivations. Neither of them is, you can't describe one of them as illegitimate and against the rule of law because it comes from an anti-capitalist ideology, and the other not.
Sure.